communications with the counsel's office in terms of your strategies for prosecuting these cases?
No.
In conjunction with your final report, a letter was prepared by President Trump's defense counsel, Todd Blanche and John Lauro, and they raise issues concerning their review of the report over the Christmas season. And they indicate that they were placed in a veritable hardship trying to review the report because the Special Counsel's office required them to come to DC. The Special Counsel's office wouldn't let them, use their laptop. They wouldn't, have access to any, internet. Can you walk us through your posture on some of those onerous conditions that Defense Counsel raises?
Sure, and just for clarity, I'm going to confine my remarks to the election side case because whatever letter they sent or didn't send regarding the classified documents case, I don't remember if there was a letter, but I don't want, for the reasons we talked about, talk about that.
I am referencing the letter in the part 1 of the report.
Okay, great. So I do recall that, and I recall being surprised and disappointed about their letter on that point because my recollection is that I'm not going to remember the specific dates, but I remember we gave them a time period and conditions to look at the report, and it was around the Christmas holidays, and they were unhappy with those conditions, and we then changed the conditions to better suit what they wanted. And I think this is in what I'm talking about, if I recollect it correctly. This may be in the letter that we attached to to the final report as well. And I remember them expressing appreciation to us for allowing them to change the schedule. That's my recollection of that. So when they complained about the schedule, I remember being surprised about that.
Okay.
And again, the letter that we wrote, I believe, reflects this, and that letter will be a better recollection of this than my memory a year from now.
They indicate in that letter, though, that they were required to delete prior discovery productions, preventing them from reviewing the underlying documents referenced in the report.
Well, the deletion of discovery, that was pursuant to the protective order in the case, and so put aside the final report of their review, the protective order that both parties signed, and again, there'll be a record of this, that protective order stated that when the case was concluded, the discovery had to be deleted, and that was an order that both sides signed with the court, so that was as much an obligation on their part to the court as to us, and by this point in time, the case is as to Donald Trump had been dismissed, whatever date that was in November.
Right, but they're reviewing the final report to try to, position their client to, make some rebuttals and that type of thing, which is certainly, I think you would agree, is a fair reason to want to have access to the report, correct?
Yes.
What types of communications did you or your staff have with the January 6th committee?
So when I was appointed as special counsel, I asked at some point whether we had gotten evidence from the special counsel, from the select committee. We had not, and so I directed my staff to get that evidence, get whatever evidence we could from them, and I think it was in December or so that we did in fact get evidence from them and get a copy of their final report. And this is the this is referenced in the in our final report. There's a paragraph or footnote regarding that.
Okay. Do you know who at the select committee your staff was communicating with? Were you?
I was not.
Okay, so you didn't have any communications with members or staff at the select committee?
I did not, no.
Okay, and who on your staff did?
What I recall is tasking J.P. Cooney to do this. I don't know if he then tasked somebody else or if he did it himself or with somebody else, but that's who I remember speaking to about this.
Okay. The book we've been referring to reports that on January 1, less than 48 hours before Republicans could lock down all the evidence or perhaps delete it entirely, I don't think we would do that. A committee staffer summoned an attorney from Smith's team to Capitol Hill to receive a hard drive containing the committee's work. Is that consistent with your understanding of what happened?
I wouldn't have remembered that level of detail if you hadn't read it, but we asked to get everything they would give us, and we took everything they gave us, and we disclosed to the defense everything we got.
Okay. You disclosed everything you received from the
Yes,
January 6th
the stuff we
committee?
got from the January 6th committee, I directed my staff to disclose it to the defense.
And the book reports that, Cooney drove to the Capitol and at the last minute succeeded in collecting 2 hard drives containing about 200 interview transcripts, less than 24 hours before Republicans began shutting down the committee's website. Is that something you have any recollection of?
That level of specificity, I don't. I can't say that that's not accurate, but I don't recall that level of specificity.
And do you know if the hard drives that you obtained contained video of the interviews the January 6th committee conducted?
As I sit here right now, I don't recall one way or the other. If they were in there, we looked at them and we provided them to the defense, but I don't know one way or the other.
And when it comes to deleting documents, while the Republicans didn't do that, what I can tell you is that the January 6th committee files, when we were able to have access to them, did not include the videos that they recorded. And so the question is, do you know, and I apologize if I'm repeating this, but do you know if the Special Counsel's office, took possession of the videos of the interviews? Because we didn't get it, they were gone by the time we had access to it.
Yeah, as I sit here now, I don't know. What I recall is give us everything you can, give us any evidence you can, and then we reviewed that evidence and disclosed it to the defense. What it included in terms of that level of specificity, I don't have that recollection right now.
The videos that they used at their at the public hearings were obviously snippets, and they were they were cherry picked. I don't really mean that in a pejorative way, but they were selected to make the points they wanted to make. And if there was a defense attorney involved with the proceeding, if there was a active minority involved with that proceeding, we would have had a chance to point out that the videos are selectively edited and didn't have the full context. And you would agree as a prosecutor that if there is a video, you'd want the whole video, not just the snippet.
Yeah, we asked for everything they would give us, so we wanted whatever they were willing to give us.
Okay. Let's mark the next exhibit, which will be number
18 and 19.
These are exhibits relating to
Thank you.
what I referenced during our last hour about President Trump's access to classified information. Was it your understanding that the skiff that was in existence at Mar-a-Lago before President Trump, left office, was it your understanding that there was a possibility they could have recommissioned that skiff?
Can I just take 1 minute to look at this?
Of course.
Yeah. Okay. Thank you for allowing me to look at that.
Sure. So you would agree if an individual, not necessarily President Trump, is being prosecuted for mishandling classified information and is going to trial, you would agree that putative defendant would have, ought to enjoy the ability to discuss the charges in a skiff with his lawyer, correct?
Yes,
Have an ability to review the documents in question in an environment with his lawyer, correct?
in a skiff, yes.
Right. Now, if, in President Trump's case, he had a decommissioned skiff at Mar-a-Lago, correct?
I am not sure about that. That may be true. I don't recall that, but
Okay.
I'm not, if there's a filing that says that,
Do you have any recollection, did the defense ask that, the skiff be recommissioned or a secure area at Mar-a-Lago be established so that he can have these communications with his lawyer?
what I recall is that there was a skiff at some point at Mar-a-Lago, or a temporary skiff sort of thing. When you say decommissioned, I didn't know that there was anything like a skiff, unless you can show me something otherwise. I don't remember there being a skiff like there that was like there but not being used. I'm not sure, and again, maybe that's my recollection, but our position about this is reflected in this filing, and it's in sum that the government was not aware of any case in which a defendant had been permitted to discuss classified information in a private residence. And this would be exceptional treatment consistent with the law. I'll just add one other thing that might be helpful is we did work with the FBI to make Donald Trump's review of classified information at the skiff, and I think it was in Miami, more convenient and easier. I do recall having conversations to do that. We did oppose him having classified documents at his home and social club, which is the same place where he was keeping these illegally. So that is accurate.
Right, but if a skiff was established, this isn't just any normal person. This is the former President of the United States, now current President of the United States. And, if a skiff could be recommissioned at the Mar-a-Lago residence, why would you have an issue with that?
Well, I think you just hit on it. Any normal person. He should have the same rules as everybody else. And he, at this time, was a private citizen. And I'm not aware of any private citizen in a litigation, no matter how important a person they are, no matter how busy they are, being allowed to have a skiff in their home for their convenience. Again, I think my recollection is we worked to make his review of classified documents at the skiff, and I think it was in Miami, more convenient, and we did that, but I did not think it was appropriate because I think he should be treated like anybody else.
Okay.